All right, are we ready? Going live in 5, 4, 3, 2, 1. We are live.
Good evening. Welcome to the October. Sorry, technical difficulties. Okay, I should be fine now. Okay, good evening. Welcome to the October 23rd, 2025 Random Housing Committee regular meeting. This meeting is called at 6:04 p.m. I will proceed with the roll call. I can see everyone's in attendance. We will now move on to item 3, consent calendar. These items will be approved in one motion unless any member of the committee wishes to remove an item. Public comment will occur after the discussion. We invite you to submit a speaker card now or raise hand on Zoom. Would any member of the committee like to pull an item? Seeing none, I will move on to public comment. Please raise hand on Zoom or star 9 on your phone. Seeing none. Vice Chair Cox.
I make a motion to accept the consent calendar as written.
Second.
Motion to accept the consent calendar as written, which is the minutes. Actually, you need to, Vice Chair Cox, you need to state
Okay,
the title.
I make a motion to move item 3.1 minutes for the September 25, 2025 and October 4th, 2025 RHC meeting on the consent calendar.
Okay, any further discussion on the motion? Seeing none, go to vote. Passes unanimously. We will now move on to item 4, oral communications. We will now open this meeting up for any comments from the public. Anything on this item, for persons wishing to address the committee, this is up for items that are not on the agenda tonight. Please raise hand on Zoom, press star 9 on your phone, or submit a blue speaker card if you're in person. Seeing none, I will close oral communications and now move on to item 5, the appeal hearing. So this is item 5.1, appeal of hearing officer's decision regarding petition numbers C-2425-36 and C-2425-37.
Chair, can I just mention that we do have translation tonight, so if everyone can speak just a little bit slowly to give our interpreter time to translate.
Got it.
Thank you.
Okay. Do we have slides up? The Rental Housing Committee, in hearing the appeal, is acting in a quasi-judicial fashion and will conduct the hearing in accordance with those standards. Staff will detail the appeal hearing process in their presentation. Before we get started, RHC members are required to disclose any communications that they have had with any of the parties to the petition or the party's representatives and the substance of those communications since the date that the petition was filed. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to an RHC member that is not part of the record is not to be considered in the hearing. Do any RHC members have ex parte communications that need to be disclosed? Seeing none, we will now proceed with public comment for agenda item 5.1. Are there members of the public who are not parties to the petition who would like to speak? In-person public comments we call to speak first. For those on Zoom, please raise hand or press star 9 on your phone. Seeing none, we will now move on to the appeal itself. We will move on to a staff presentation.
Just making sure you all can hear me before I get started.
You're good.
Okay, great. Thank you, Chair. So the purpose of this item is to consider the tentative appeal decision that was issued and either accept that decision or modify the decision with instructions to staff citing appropriate evidence in the record to support any changes that are recommended or adopted. So I will review the Rental Housing Committee's decision process, followed by a schedule for the appeal hearing, and finally we'll conclude with a summary of the petition, the appeal, and the tentative appeal. The tentative appeal decision. So the Rental Housing Committee has a number of options on appeal. You can do a review on a closed record, which means that you would make a decision based only on the facts in the decision written by the hearing officer. You can choose to have a de novo hearing in which you would follow the formal hearing process to potentially accept new facts before reaching your decision. Or lastly, you could remand all or parts of the decision to the hearing officer to re-examine, in which case they could potentially accept new facts. The Rental Housing Committee must exercise its independent judgment when it comes to questions of law, such as statutory interpretation. For questions of fact, the committee must determine whether or not each appealed element of the hearing officer decision is supported by substantial evidence. And this does not mean you have to reweigh the evidence or relitigate the issues. However, you may come to a different conclusion, even if looking at the same record. At this time, staff is not recommending that the committee conduct a de novo hearing. Simply does not require it. There's sufficient evidence in the record, and the existing record demonstrates adequate review and ample opportunities for the parties to present relevant evidence. So just as a reminder, this is partly for the parties as well as members of the public, but the petition that was filed by the tenant in this case defines the scope of the hearing officer's decision, and similarly, the appeal that was filed by the landlord in this case limits the scope of the Rental Housing Committee's review on appeal. So this means that you should not relitigate or reweigh, reconsider issues that are not raised by the landlord's appeal. So a summary for the appeal hearing. We're in number one, which is the staff presentation. This will be followed by opportunities for both the appellant and the respondent to make a presentation, followed by rebuttal, and then Rental Housing Committee questions for staff, and then for the parties. And finally, we will conclude with Rental Housing Committee deliberations and your decision. So starting with a quick summary of the petition, there were actually two petitions that were filed in this case for the same property. The first is an unlawful rent petition that provides that the landlord charged excess rents or unlawful rents because they were not substantially compliant with the CSFRA. Namely, they failed to register the property in 2022, and during that year they imposed a rent increase and then all subsequent rent increases following from that one were unlawful because the initial one was unlawful. And then the second part of the petition asserted that the landlord failed to maintain in a habitable condition the rental unit and decreased housing services, specifically that there was an infestation of rats, an infestation of cockroaches, that there was a partially non-working stove in the rental unit, as well as an inoperable refrigerator. So the hearing officer's decision concluded that the petitioners met their burden of proof that the landlord was not in substantial compliance with the CSFRA. The landlord or their predecessor in interest in this case failed to register the property in 2022. They did impose a rent increase during the time that they were not registered. And so all subsequent rent increases following from that one were also unlawful because they did not roll back the unlawfully imposed 2022 rent increase. The hearing officer also concluded that there was, in fact, a rat infestation in the unit or on the property that violated the warranty of habitability. And in that case, the hearing officer awarded a reduction in rent and found that the landlord was 100% liable for this issue. And then as to the cockroach infestation, the hearing officer concluded that the petitioners did meet their burden of proof that there was a cockroach infestation in the unit, and that violated the warranty of habitability. However, because the petitioner's conduct contributed 70% to this condition, namely, the hearing officer concluded that the petitioners did not keep the unit clean or in a sanitary condition, which contributed to the cockroach infestation or the persistence of the cockroach infestation, and therefore concluded that the landlord was only 30% responsible for the infestation. And then finally, the hearing officer concluded that the petitioners did not meet their burden of proof to show that there was a defective condition of the refrigerator. And sorry, I realized I have been speaking relatively fast, so I'm going to try to slow down for the interpreter. So the landlord's appeal raises 4 issues. First, that the hearing officer erred or abused her discretion in assigning 30% of the responsibility to the landlord for the cockroach infestation. The second issue is that the hearing officer erred or abused her discretion in assigning 100% of the responsibility to the landlord for the rat infestation in the unit. And the main argument here that the landlord makes is that the hearing officer should have applied a comparative liability analysis as she did for the cockroach infestation issue, and should have considered how the petitioner's conduct contributed to the rat infestation in the unit as it did to the cockroach infestation. The third is that the hearing officer erred or abused her discretion in failing to consider evidence of the landlord's improvements in the affected unit. Namely, there is evidence in the record that the landlord did approximately $50,000 to $70,000 worth of improvements to the rental unit. And the landlord is arguing that the hearing officer should have considered this and essentially provided them with equitable relief because of the investments that they made to improve the unit that were unrelated to the cockroach infestation or the rat infestation. And then finally, the appeal requests clarification of the conditions for restoration of the lawful rent level, including clear benchmarks for abatement verification. So essentially what this is asking for, it is saying that the hearing officer's decision is not clear when the landlord will be able to restore the rent to the lawful rent level, and requests clear benchmarks or uh, requirements for when they have satisfied the requirement to correct the infestation in the cockroach infestation in the unit, and when they can begin charging the full lawful rent for the unit. The tentative appeal decision recommends affirming the hearing officer's decision in its entirety. Um, uh, the issues of lawful rent were not appealed, so this is just reiterates that the lawful rent for the unit is $2,500, and that the petitioners are entitled to a rent refund for any excess rents that they've paid above that amount. As it relates to the rat infestation, the decision would recommend upholding the 20% rent reduction that was ordered by the hearing officer for the period from April 20th, 2023 to September 30th, 2024. And the reason for this is that there is simply no evidence in the record that the petitioner's conduct contributed to the rat infestation in the unit in the same way that their conduct contributed to the cockroach infestation. Largely the findings around cleanliness and sanitation and hygiene were limited to the areas of the kitchen, while the rat infestation was basically throughout the property and throughout the unit, including in the laundry rooms. And so there's just not evidence in the record to support a finding that the petitioner's conduct contributed to the rat infestation, and that the hearing officer should have applied some sort of comparative liability analysis as related to the rat infestation. With the cockroach infestation, the tentative appeal decision also recommends upholding the hearing officer's decision to award a 4.2% rent reduction for the period from April 15th, 2023 through the date of this hearing, plus an ongoing rent reduction of $105 per month until the condition is corrected. And the reason for that is one of the landlord's arguments was that this issue started before they purchased the property, and therefore that should have been taken into consideration, and that their conduct of rehabilitating the unit and some of the issues with the renovations that they did that the hearing officer concluded contributed to the cockroach infestation should have been disregarded because this issue started before they purchased the property. The CSFRA does hold landlords liable for the violations or omissions of their predecessors in interest. And especially in this case, the landlord did receive disclosures from the seller of the property, the prior landlord, letting them know that there was an ongoing cockroach infestation. And so it's clear that they assumed responsibility for this issue. And so for that reason, the decision recommends that the 30-70 split of responsibility between the current landlord and the tenant as to the cockroach infestation is supported by substantial evidence in the record. And then relatedly, as it relates, since the stove issue is related to the cockroach infestation, it upholds the hearing officer's decision that the tenant and the landlord share the cost of a replacement stove, again in that 70-30 split. The fiscal impact, so any decision of the Rental Housing Committee on appeal, including adoption or modification of the tentative appeal decision, could lead to litigation, which would have fiscal impacts on the program. Notably, one purpose of appealing a hearing decision to the Rental Housing Committee is to ensure that the decisions are legally defensible, and so the appeal process reduces overall risk of legal liability and legal expenses. And so, as always, the recommendation is for the Rental Housing Committee to consider the tentative appeal decision and either accept or modify that decision with instructions to staff, citing appropriate evidence in the record. Thank you.
Thank you. We will now move on to the appellant landlord. The appellant landlord, please raise hand on Zoom if you'd like to speak, and staff will promote you to be a panelist. You'll be given 10 minutes. Timer should be on screen.
Hello, can everybody hear me?
Yes, we can.
Hi, I'm speaking on behalf of the Selective ARPU Family Trust. So first off, I just wanted to say thank you so much for taking the time to hear our appeal. I think the presentation just now did a great job of summarizing the case. I wanted to clarify just a few things. First off, regarding the CSFRA, we did not know at all about the registration requirements, and as soon as we did find out, we promptly registered within a year of even buying the property, and we fully accept liability that the rent increases that we issued while not being in registration with CSFRA were unlawful, and in our appeal, we don't appeal that at all. The fact that we did make some unlawful rent increases, and we are fully prepared to pay back all the unlawful rent that we collected from the tenants. Moving on to the cockroach infestation. Again, it was pretty well summarized in the presentation. We just wanted to add a few details, mainly the fact that we had already gone through with some pest control services, and we had hired pest control throughout the entire lease of the tenants, and they were always coming in. And we also note that despite this unit being the farthest away from a nearby garden, which was the source of many pests, including rats and cockroaches, only this unit, which is in a fourplex, experienced issues with cockroaches and rats both, whereas the other 3 units, each of which were closer to this garden, kept their units more clean and experienced no issues, or whatever issues there were easily mitigated by the help of the same amount of pest control that was assigned to this specific unit as well. And that's why we're moving forward to hopefully modify the 30% assignment of blame for the cockroaches a little less on us, because we believe that we did what we should have in our power and our responsibility as landlords to mitigate the cockroach infestation problem. And regarding the rat problem, while we agree, yes, there was a package that we did not fully understand that we needed at the time, given the pest control, we did what we thought was best as landlords, because again, we were not fully aware of the situation, and we had seen the same level of pest control work for the other units in the property. And we did not think that we needed to, purchase an extra overkill for a problem that wasn't a problem at this time. And it's also, if you do a quick Google search, you can also see that rats do eat cockroaches in times of despair, which for most pest life is always times of despair. So we also argue that if there is a cockroach infestation, that it was caused mostly by the tenants, as said by the hearing officer's decision, then that can also definitely increase a risk of rat infestation.
And furthermore, we replaced the brand new stove.
And furthermore, yeah, just as a motion to show our like a move of good faith, we have already actually replaced the stove with a fully working stove in the unit.
And for the last 2 months, they said pest control is not needed anymore inside the unit.
And we also have written proof from the tenant that pest control is no longer needed for the unit. At the same pest control service, Clark Pest Control, that which we have been in contact with for this property since the time of this issue becoming an issue, have now been able to mitigate this problem in full.
And we have written proof of in the SMS text.
Anything else?
Yeah, that's better.
I think that's it on our side. Thank you so much.
Thank you.
Excuse me, can we get both full names of the people who just presented? Just for the record.
So my name's Ayush Satyavarpu.
And my name is Srinivas Satyavarpu. I'm the owner, and Ayush is my son.
Thank you.
Thank you.
Now we will move on to the respondent tenant. Respondent tenant, please come to the podium if you like to speak in person. Evening. You would have 20 minutes, 10 minutes for the address and 10 minutes for the translation.
Thank you.
Mi nombre es Gustavo García Pérez y les digo hola a todos.
My name is Gustavo Garcia Perez, and I'd like to say hello to everyone. Oh, can you hear me? Can you hear me? Thank you.
Okay.
Sí, adelante.
Yo quiero hablar acerca de las acusaciones de este señor, el dueño, que dice que las cucarachas y los ratones son a consecuencia de que nosotros tenemos el departamento sucio. Es una total mentira. Somos de las personas que tenemos el departamento más limpio. Y pueden ir el día que ustedes quieran a revisar, si ustedes gustan, si así quieren.
I'd like to answer back on some of the items that were explained earlier, especially regarding the rat and cockroach infestation. I'd like to say that what was shared is a complete lie. We do not keep our apartment dirty. We have one of the cleanest apartments, and we invite anybody to stop by unannounced and check for themselves.
Cuando nosotros nos movimos a ese departamento no había cucarachas. Las cucarachas empezaron, me parece que en el marzo 25 de 2024 y fue controlado hasta ahora unas semanas antes de esta corte. Yo personalmente le mandé un mensaje al señor dueño del departamento, Srini, que ya no tenía cucarachas, que yo no ocupaba más el pest control. Desde entonces ya no hemos tenido problemas con esos animalitos.
We did not have a roach infestation or problem when we initially moved in. The problem started on March 25th, 2024, and it was just controlled weeks before this whole thing started. I did send a message to the owner at that time to let them know that we no longer had roaches and we no longer needed the pest control services. It was no longer needed.
También nosotros vivimos en un constante acoso con miedo de que se nos amenaza que si descomponemos la estufa o cualquier cosa que esté en el departamento, nosotros tenemos que pagar por ello. Entonces nosotros somos una familia que tenemos 3 niños pequeños y tenemos que cocinarles todos los días. Entonces necesitamos usar la estufa. necesitamos usar todas las cosas que tenemos dentro del departamento, como la secadora, refrigerador y la estufa que él nos provee. La lavadora no la menciono porque esa yo la compré en la Home Depot y es ahora que todavía no la pago porque no acabalo para pagarla, pero la voy a pagar algún día.
I also want to add that we've lived scared constantly, always feeling threatened by the owner. He constantly lets us know if we break the stove, we are to pay it 100% ourselves. We are a family with 3 kids in the home. We need to cook daily. We use all the equipment or all the appliances that we have in our apartment on a daily basis because we do have to cook for our children. That includes a dryer, a refrigerator. I won't mention a washer because I've bought that myself at Home Depot and don't even have the funds yet to pay it off. I'm still paying for it.
Bueno, ahorita es todo por hoy y muchas gracias a todos por escucharme.
That's all I have to say for now, and I'd like to say thank you for listening to me. Gracias.
Gracias, thank you.
Thank you. We will now move back to the appellant landlord. You have 5 minutes to rebut any statements made by the respondent. Please limit your comments to rebuttal rather than repeating any information you may have said earlier.
Hi, just give us 20 seconds real quick. Thank you.
No worries.
Okay, first off, thank you for your response. We wanted to first off say that we do recognize this is a space of law and opinions are obviously going to fly, but we do have proof from our pest control services when we did contract them in writing with them saying that when they did go to the unit to perform the pest control servicing, they did note that because of the state of the apartment, that's a big reason why the infestation was being caused. So we are not just saying this as landlords on our opinion. We have proof from our pest control servicing of them saying this. Second of all, we wanted to note it that as for feelings, we're sorry that we make you feel scared. That was never our intention. To clarify why we said that, there have been multiple times over the course of the lease that these appliances, which have been brand new, have been broken and had to been replaced at the cost of the tenant or of the landlord. And we want to emphasize that it's not reasonable for us to just keep paying and paying for new appliances if they're being broken with no reasoning. But we did not mean to scare or threaten at all, and we apologize if it came off that way. That's it. Thank you so much.
Thank you. Respondent tenant, you have an opportunity to rebut any statements made by the appellant landlord. Please limit your comments to rebuttal rather than repeating information already said. You will have 5 minutes to speak, as well as 5 minutes of translation.
Tocante la estufa, dice que está quebrada. En muchas ocasiones siempre nos culpó, como ahorita que nosotros somos los culpables. Él tuvo la osadía de traer al pest control, al hombre del pest control, para estar seguro que esa estufa había sido descompuesta por nosotros. El pest control enfrente de mí le dijo, la estufa se quebró debido a que las cucarachas se meten y hacen cortocircuito. Y él me dijo, yo voy a traer al pest control para comprobarte y una vez que yo te compruebe, tú vas a pagar. Bueno, pasaron semanas cuando el pest control le dijo, la estufa se quebró porque las cucarachas se metieron a los cortos y le enseñó cómo funcionaba. Y este hombre pues no dijo nada, simplemente se fueron y nos dejaron ahí. Y ahora me está culpando a nosotros, que porque tenemos sucio, que porque esto. Estoy seguro que ahora que no tenemos cucarachas, la estufa va a estar mucho mejor. Y todos los aparatos que tenemos en la casa.
I just want to repeat that pest control was called, and I was told they were to be called to prove that we had broken the stove. As pest control came, they did show and explain that the stove was not working due to wires possibly being cut or broken through because of the roach infestation. As they were explaining this, the owners actually left, and it was the pest control people that shared with me that that's why the stove wasn't working. Now that we do have a new stove and we do not have a roach infestation, I'm almost sure that things will work accordingly, not only with the stove, but with all appliances. Gracias.
Otra cosa, el dueño nunca mencionó que durante la construcción no nos rentó un hotel, nos tuvo allí a merced de los hombres que construyeron allá adentro, repararon con sheetrock, pintura, y nosotros movíamos los muebles por nuestra cuenta. La verdad, tuvimos más de un mes con muchos problemas que no podíamos ni dormir bien porque tenían materiales, cajas de materiales de todo tipo. ¿Y qué podíamos hacer nosotros? Yo pienso que la obligación de él era habernos rentado un hotel en lo que él terminaba lo que tenía que hacer dentro de nuestro departamento. Y yo pienso que ahí venían muchas cucarachas porque había cajas de todo tipo. Venían de la Home Depot, venían no sé de dónde, y ahí las metían adentro de nuestro departamento y teníamos que vivir con ello. Es todo.
One thing that was not mentioned was that during the construction time, when they were working in our unit, we were not provided a hotel. We had different men coming in and out during the construction that had different material, sheetrock, paint. All of those were in our house, and we had to move our own furniture while they worked on this. We had various material boxes there and couldn't sleep during that construction while living through all this. We feel they should have rented us a hotel room, and possibly roaches could have been in these boxes because they were coming from various places, one of them being Home Depot, and we had to live with all of those boxes with the material inside our home. Thank you. That's all.
Gracias. Thank you.
Thank you. Gracias.
Thank you. Now we will bring it back to the committee. Does any member of the committee have any questions for staff? Seeing none, does any committee member have any questions for either the landlord or the tenant? Seeing none, we will move on to deliberation. Committee Member Balch.
So the federal government, the IRS, considers property ownership to be passive income. And I've learned it is not passive. Anyone doing this becomes an active participant, or it doesn't work very well. So there are a few points here which I think are really important for everyone to understand, and I hope that there are property owners in Mountain View who do follow these proceedings, because if you're on the wrong side of the law, it's very difficult. First of all, it is important to recognize that the CSFRA is a charter amendment, which means that neither the City Council nor the Rental Housing Committee has the ability to modify any of the critical terms or essence of how it operates. It doesn't matter if we think it's right or wrong, it is simply not an option. The only way to change it is through the ballot box, and people will have to decide how they want to deal with that. First of all, we do not generally relitigate. We are basically looking to see whether the hearing officer has come to a reasonable decision. Under the circumstances, and I'll go through them, I believe that the hearing officer did come to a reasonable decision. One of the really, really difficult issues with the CSFRA from a property owner perspective is that there's no statute of limitations. Once that rollback gets missed, that's it. You have to start from scratch. You have to go all the way back. And so the longer that waits, the more liability piles up. That is the term of the CSFRA. And again, the Rental Housing Committee or the City Council have no ability to modify that. In terms of capital improvements, which is a point made, the only way I'm aware under the CSFRA to deal with that is to file a petition for a fair rate of return. There is no automatic consideration or other effect that capital improvements will have on any type of a rent situation, certainly not during a petition process. The final point I'll make is that the only way I'm aware to deal with situations where a landlord believes that a tenant is not cooperative when it comes to maintenance issues or cleanliness is to file a quit, is basically to recognize that they're in a situation that is not being remediated. They believe that they're doing the right thing. They believe that the tenant may not be cooperative, and there is a legal process for that. Barring that, I'm not aware of any other way to deal with it, certainly not under the CSFRA. So that's why my recommendation is that we should approve the hearing officer's findings because the regulation is clear, the legal obligation and processes are clear, and it's very difficult when a property owner is not aware of these requirements and subtleties of the law.
Member Keating.
Thank you. So I too will be supporting upholding the hearing officer decision and denying the appeal. And one of the things I'm noticing is that there was a shared responsibility, and at least for the things related to the items related to the kitchen. And you know, I'm trusting the hearing officer to have done a good enough job at deciding where that responsibility lied between the landlord and the tenant. And I do have a question for staff. So the appealed elements, looking at the PowerPoint, include D, request clarification of conditions for restoration of lawful rent level, including clear benchmarks for abatement verification. And is that a request that comes to the committee or not? Because I'm not sure if I'm clear about how we are responding and if we are to respond to that request in the appeal.
So the tentative appeal decision does find that the hearing officer's decision is clear about when the landlord is able to restore the rent to its lawful level. That is the final section under the discussion. But in addition to that, as all hearing decisions as well as appeal decisions state, if there is some sort of disagreement, which in this case it appears that there's not disagreement between the parties, as they've mentioned tonight, about when the issue is resolved, then either party can request a compliance hearing, in which case the decision or the request will go to a hearing officer to determine whether or not the party, in this case the landlord, has complied with the requirements of the hearing decision.
And just to follow up on that, then what is the timing for a annual rent increase being valid once the habitability issues are addressed?
I'm not sure what you mean by annual rent increase being valid.
Are you asking when can the landlord raise the rent?
Yes.
After the rollback? In accordance with the decision, they have to pay back all of the funds, the overcharges, and resolve the infestation issue, which I think both parties testified it seems to be resolved. So once the funds are paid back, then they would have to give notice in accordance with state law.
Thank you.
Vice Chair Cox.
Yes, I'm going to also support upholding the tentative appeal decision in its entirety, and my reasoning largely follows that of what's in the tentative appeal decision. I believe that the landlord is partially at fault, with respect to the cockroach problem. I mean, because of the evidence that was given. I mean, first of all, that he tried to use even the idea of this idea as a defense that the problem was there when I got there. Well, okay, I mean, that establishes, that the problem was there and steps weren't taken to do anything about it. And so that's a key thing, okay? On the other hand, there was also the testimony, during the hearing that, I mean, the stove was not being kept up, and it was a new stove. And, I mean, that it would just fail within that short period of time is a real, that also confirms the idea that there was the preponderance of the problem was due to the not keeping the stove in working order and clean enough. So I agree with the hearing officer that most of the fault lies on the tenant, but that it's also the landlord's responsibility too. And the 70-30 split, I think, is a reasonable one. I mean, hearing officers have, fairly wide discretion under our current CSFRA rules. And so, I'm not going to sit here and talk about whether it should have been 20 or 40. I mean, 30 is reasonable. So now on to the rats. Again, I mean, this comes back and this has come to us multiple times. The whole point is that, an attempt to cure the problem is not sufficient, and you don't even get partial credit for it. You have to actually cure the problem in order for it to be done. Now, apparently something was done because both the landlord and the tenant agree that the problem doesn't exist now. I wish I had heard in the hearing recording, because I know the first attempt was putting out traps, and I'd like to know what it was that cured it, but they cured it. But again, I mean, just putting out the traps apparently wasn't sufficient. And so I mean, as it was noted in the report, I mean, it was possible to take a more aggressive treatment, and that could have been done, and that's just something the landlord has to decide when he tries to cure the problem. Is he going to try something that might work or something that might be more expensive and will work? So again, this all goes back on the landlord as far as I can see. And, you know, the third part, you know, this idea that somehow these, you know, very expensive upgrades should, you know, mitigate these issues and reduce how much, you know, the landlord is liable. I mean, a key thing here is just that, you know, what we're talking about is the habitability conditions and what was done to address them. I mean, you know, the whole idea of putting more money into the apartment and make it a nicer apartment is not on point. And so, I mean, it just doesn't come into the decision. I mean, that's the landlord's decision. He did it at his own discretion, and it's just not on point. So those are my reasonings, and I could even make a motion now, but if somebody wants to keep talking, we can do that too. Can I make a motion and then others can still talk?
You can do so, yes.
Okay, so I'm going to make the motion to uphold the tentative appeal decision in its entirety.
And state for the record that Member Brown has seconded.
Second.
You get your chance. Member Statsislop.
Thank you. I'll be brief. I always understood the role of the Rental Housing Committee on appeal is you were looking at, did the hearing officer use legal reasoning and apply the evidence that was submitted and come to a conclusion that a reasonable hearing officer would come to. We're not deciding, is that what I would have done? You're just deciding, did they abuse their discretion and did they come to a reasonable conclusion? I think the hearing officer did a very thorough job of weighing the impact of tenant actions versus landlord actions regarding the stove. The other thing that I just also want to note with my understanding of service reductions in housing, it's not about the good faith effort of the landlord to cure the problem. While the problem exists, that is a service reduction. It's not, you know, whether they're being a bad landlord or something. The tenant's not getting a fully habitable place, so they shouldn't be paying the full rent for that. Lastly, I thought this would be a good opportunity to tout the available to all landlords and tenants Mountain View mediation program, which just celebrated its 50th anniversary. That program, the case managers there, I would encourage landlords and tenants to call them. You don't have to have a dispute, but if you're having a communication issue for a landlord who may feel like for language barriers or no language, just not hearing each other, to utilize this free available service, and they have case managers that speak Spanish, there's language translation available, but this is a way to get ahead of things before they become a problem, and it's free to use. You could explain, I just need help talking with my tenant about how they can, you know, work with the pest control to do what they need to do to prevent more roaches from coming. So please, anybody listening, landlords and tenants, it doesn't have to be a negative thing. You just want some help in communicating and how to best work with your tenant or landlord. And I will be affirming the decision.
Member Brown.
Thank you, Chair. I did not see any evidence presented tonight that Ms. Chandler erred or abused her discretion in any of the decisions in the hearing officer decision. So I would also support affirming it. Additionally, I think that our staff does like a very thorough job of making available resources to landlords and tenants to understand their rights and responsibilities. And I think that it is incumbent on any property owners in the city to know their responsibilities and rights. And so please take advantage of what we have. Go to the Housing Help Center, check the website. We have a lot of FAQs and guidance. They're here to help to avoid things like this. Mediation is also great, but knowing that what you have to do before you ever get there, stay informed. One more thing, I do find in these hearings that it is a little distasteful to bring up facts that are not material to the appealed elements in cases like this. I think that I would appreciate for anyone coming before the RHC to just stick with the things that you're appealing in a way that is trying to serve the goal of coming to a good decision on the facts, not attacking the other party. Thank you.
Any other discussion? I guess it's my turn. I agree with the thoughts of my fellow members that there's been no abuse of discretion, that the CSFR requires that the issue at hand to be fully addressed rather than attempted to be addressed, and that we do have mechanisms to clarify if there's any situations where either party believes that the hearing decision is vague in any situation. With that, the motion made by Vice Chair Cox, seconded by Member Brown, to accept the tentative appeal decision is now up for a vote. Motion passes unanimously, and that ends the item. Moving on to item 6.1, the study session on, actually it's not so. Tenant anti-retaliation and anti-harassment protections.
Thank you, Rental Housing Committee members and Chair. This is a presentation on a issue that the Rental Housing Committee requested. Back in March of 2025, we held a first study session. And as a result, we have drafted regulations for your review and feedback today. At the time in March, you reviewed federal, state, and local policies of comparable jurisdictions. And today we propose some regulations that are based on best practices from policies by other comparable jurisdictions. So these draft regulations ban retaliation and harassment, give ample examples of what might be considered retaliation or harassment, with the main purpose to help landlords and tenants better understand their rights and responsibilities. And it also lays out some remedies and enforcement measures for potential violations. We also added some definitions to Chapter 2 that, for instance, bad faith, harassment, and retaliation. And we also added some definitions for specific categories of individuals. So we added a new Chapter 14 in the CSFRA and a new Chapter 13 from the MHRSO. So the purpose, as stated, is to provide protections against harassment and retaliation, and it is applicable to landlords and tenants that are covered under the CSFRA and the MHRSO. The next section provides some anti-retaliation examples. That varies quite a bit from requesting repairs or maintenance to complaining about the condition of housing services, filing a petition, or requesting reasonable accommodations and get a retaliatory action or non-action from the landlord. Similarly, there is also a list of examples of anti-harassment provisions and examples of landlord behavior, such as violating the covenant of quiet enjoyment, interfere with a tenant's right of privacy, refuse to acknowledge receipt of a tenant's land for rent payment, or other repeated acts or omissions to substantially interfere with tenants' rights. And the last section is about remedies and enforcements. I will not go through all of them. You can find them in the memo and in the actual draft regulations. These are drafted based on best practices in other comparable jurisdictions. So the next steps would be to receive feedback from the Rental Housing Committee, implement your recommendations, and submit the final regulations draft for approval by the Rental Housing Committee at an upcoming meeting. Happy to answer any questions you may have.
All right, we will now move on to questions. This time is limited to only questions from committee members. Afterwards, we would take any public comment. Member Satsislop.
So, I have a few notes. I have things I want to make comments on, but then I have a couple sections where I'm trying to understand the meaning. Is that where I can do questions for now?
Free to ask.
Okay. One question in the regulations. Let's see. Find the number. It's D to C4. So it's on page 7. This is the entry to show the rental unit to a prospective or actual purchaser if the landlord has not notified the tenant in writing within 120 days of the oral notice that the property is for sale. I'm trying to parse out what this means with the 120 days. Is the gist of it that you, like, if 3 months have passed, that's kind of like your notice to the tenant has expired and you need to, let them know again that you're going to sell it?
Sorry. So this is actually a requirement that is in state law itself. It comes from Civil Code Section 1954, which provides that if a notice is given orally to a tenant that a landlord will be showing a unit to prospective or actual purchasers, then they have to follow up within 120 days of that oral notice, confirming to the tenant that the property is for sale.
Okay, that explains why the state law is always written interestingly. So it could maybe be written a little more plainly. I know this is just a draft, but
yes,
I'm not giving myself a whole lot of credit, but if I'm struggling to understand it, I can't imagine others. I think that's, and I think in like F, rent payments, subpart 4, that's another one that could be, this is about like the form of payment of rent. I'm sure it's taken from state law, which is why it's confusing to read. So that's just one that could be kind of maybe put more in plain language. But I think I understand what that one is getting across. That was my question.
All right, does any other member, Member Balch?
Yeah, thank you. A couple of questions, both regarding rent payment and the point about refusing to accept or acknowledge receipt of a tenant's lawful rent payment. How does this relate to the landlord's right to not accept a partial rent payment? Would that be considered harassment?
No, that would not be. And I believe that section, I'm scrolling to find it.
Yeah, I mean, it does say the tenant's lawful rent payment. So I think that is intended to mean the full rent.
Okay.
Great.
Okay. Thank you. And then the second question, I'm just trying to parse and F sub 4, which is failing to allow the tenant to pay rent using at least one form of payment that is neither cash nor electronic, such as, is this, and the example given is that a check that has been returned for insufficient funds, is this saying that the landlord must continue to accept checks, or cash is or like a money order? Like, what is the actual point of this? What is the?
Yes. Yeah. So, and we can certainly try to clarify some of these. But essentially, what this one is saying is, and again, this is a requirement in state law that a landlord does have to provide a tenant with one other method by which to pay rent or a security deposit that is neither cash nor electronic funds transfer. And then the IE that is being, it is intended to modify the second clause of that section, which is that except where otherwise permitted by the state law. Because state law provides that if a tenant has previously, so essentially if they've previously tried to pay with a check or some other manner in which, and then the check bounced, in that case, the landlord does not have to offer them the ability to pay with something that is neither cash nor electronic funds transfer.
Okay, thank you.
Vice Chair Cox.
Yes, so in a previous hearing, the issue was brought up that, landlords, some people brought evidence to say that landlords had turned them, if they were undocumented immigrants, they were turned into ICErs. And I'm just wondering, I didn't see anything in here about that as a harassment or a retaliation or anything like that. And I'm guessing that we can't do anything about it because if you have undocumented status, in a sense, you're just not here legally, okay? But I mean, I'm just wondering what the thought process was staff around this issue. I mean, and is there anything, we can do, or are we just not able to do anything?
So that is in both the retaliation and harassment sections. It does talk about violating state law because there is a state law prohibition on landlords reporting their tenants to immigration or other law enforcement based on their citizenship or immigration status. So let me point out to you what sections those are in.
It's G. It's the next section after the rent payments.
Yes. No, there's a more specific one. Yes. So it's actually going to be in the privacy section. So the first one under that one talks about that. So you can't request information about someone's citizenship status. And then 2 talks about releasing or threatening to release any of the information specified in 1. And those sections, California Code sections that are cited, 1940.2A5, 1940.3, and 1940.35 are all related to these prohibitions against retaliating or attempting to harass a tenant by reporting them to immigration or other law enforcement based on their citizenship or immigration status.
Okay, thank you. I'm glad you got that covered.
All right, Member Balch.
Yeah, actually, in that privacy section, a little bit further down, imposing or enforcing unreasonable restrictions on overnight guests. There is a common provision in leases around guests, basically anyone who isn't on the lease, how many days typically they can be in the unit. What is unreasonable in this phrasing?
Yeah, I mean, that is something that is in the discretion of a court to determine, but I would just remind the committee members that as you're reading this, it's important to read it in conjunction with the very first, paragraph of which is D2, which talks about no landlord engaging or shall in bad faith engage in any of these. And so, it's the combination of an unreasonable imposition and it's taken in bad faith, as that is defined. But really, what is unreasonable in those types of scenarios is going to be a fact-specific determination that should be made by a court that has looked at all of the facts of the case.
Thank you. So then two things. So then if a typical lease has restrictions on guests, and that is prior to the tenancy being created by definition, then that's not retaliation because that's a standard part of the lease, which is generally considered to be lawful.
Correct.
Okay.
Yes.
Okay. Then the issue that the question then about it being up to the court. So if there was a legal challenge, then it would go to a court to determine what is reasonable or unreasonable. We're talking about the CSFRA, which we try to, generally speaking, CSFRA petitions don't go to court generally. Maybe some people have taken them to court, but generally not. And so is this basically saying that if there was an appeal of a hearing officer decision that found retaliation due to some, quote, unreasonable circumstance, and through whatever determination the RHC made, the parties then took it to court, the court would then ultimately make a judgment on whether it was unreasonable or not. Is that how it would go?
No. So this area in particular, there's some case law that limits the sort of administrative considerations that you all have when it comes to petitions. So you all cannot award a rent reduction based on retaliation or harassment. It's a result of case law that has come out of state appellate courts. And so if you actually go down to the remedies section, you will see that it specifically says there's no administrative consideration of this by the RHC. So in order to enforce these provisions, people need to go directly to the courts. So if there's been retaliation or harassment that a tenant wants to assert, they need to do so either in the context of they're asserting it as a defense in an eviction case, or in the context of an affirmative lawsuit against their landlord for, damages as a result of the retaliation or harassment that they have experienced. And that is also why the language in that D2 paragraph talks about what the court will consider. It doesn't, it specifically references that the court can use these examples when it is considering retaliation and harassment issues. And it doesn't reference the rental housing committee or your hearing officers.
Thank you. I fundamentally missed that. So this is I'm going to note the vocabulary. This is law in a sense, not under the RHC. This is basically, to activate this, there would need to be a suit filed in a court. Okay. Then, okay, that's really interesting. And then I guess then I'm questioning, I thought our ability to make these types of policy decisions as the Rental Housing Committee was under the banner of the of the CSFRA, where we have this kind of self-contained set of policies that whose power comes from the charter amendment, and then hearing officers make a determination, and they are appealed, and they are voted on or judged by this committee. But now the committee is creating something that is outside of our sphere.
Not necessarily. So let me give you an example of something else that is in the CSFRA. So for instance, the CSFRA says that, in order for a landlord to do an owner move-in eviction, they have to meet certain requirements. They have to do so. They have to recover the unit in good faith, occupy it for a certain amount of time, all of that sort of thing. So in order to enforce that provision, again, there's a state law limitation. You all can't have a process, an administrative process before the Rental Housing Committee to determine whether or not, a landlord has actually done the owner move-in eviction in good faith. The tenant needs to go to court to do that. And again, that arises out of case law that is well established. But you all can still adopt regulations related to owner move-in in order to try to enforce those provisions, even though it will never come to you as a rent petition. So, you can establish, for instance, that a landlord can do certain certifications to certify that they have actually met those thresholds for how long they've occupied the property and so on and so forth. So similarly here, there's language in the CSFRA as well as the MHRSO that specifically bans, bars retaliation. And there's also language in both laws that talks about limiting arbitrary evictions or taking unlawful actions to terminate a tenancy that is covered by the CSFRA. And that is where your authority and your ability to impose regulations or adopt regulations arises from in this context. So while you won't be the judge in this case, it is still within the scope of the CSFRA to talk about, to address tenant harassment and retaliation, because those issues are addressed within the CSFRA and the MHRSO.
Thank you. So is it then reasonable to say then, as you just explained it, we are in effect acting like the city council would act in adopting a regulation and then a court enforces or rules on that regulation?
That is within your authority under the CSFRA
Yes.
to adopt regulations to implement the CSFRA.
As an elected official would in the council?
Right, as the city council would. I mean, you have a limited jurisdiction.
Right.
But that is within your jurisdiction.
Yes.
Thank you.
Yes, you do have legislative functions as well as your, the quasi-judicial functions of considering petitions.
Thank you.
Member Brown.
Thank you, Chair. So to staff, have we gotten questions from landlords about retaliation, harassment, and any of the meetings we've had with the landlords where we're educating them about their rights and responsibilities?
Sorry, can you repeat?
Have landlords asked about things like this in the past for clarification to see what is considered retaliation?
No.
No?
But tenants have.
Tenants have?
Asked questions.
And so for the tenants, would this serve as a good resource to be able to provide tenants when they
I think it would be a good resource for both landlords and tenants to educate them on certain types of behaviors, so they can learn from especially the examples that we've been given.
And to add to that, I don't necessarily think landlords ask about it, but they may come to us with a situation and we might see something and then we educate them on what they should and should not be doing.
All right. Thank you.
Member Satsislip.
I'm keeping it to a question. The part E, the remedies enforcement for the complaint mechanism. Got a lot of concerns here, but my questions are, would it be verified if if the tenant's complaining that they live in the unit, like would they supply a lease or some proof of payment that they're the one impacted in this unit? Other question is, would a landlord be able to submit a response?
In connection with which part of the process?
So a tenant or their representative can submit a complaint on a complaint form and it gets served on the landlord. Is there a mechanism for a landlord? I think the purpose, and you can clarify, is just so you have on file, because there's no action taken.
Correct.
So if something's being accused of and a landlord's getting, their question's going to be, can I respond to this?
Of course.
Okay. Yeah. And I think the only thing it needs to be abundantly clear, could the city or the program take any action on those complaints?
That depends completely on the type of complaints we're getting. And I think if there's a very severe complaint coming maybe from multiple tenants about the same issues, the rental housing committee or staff could think about forwarding it to the city attorney's office for further investigation.
Okay, maybe that needs to be in here, because what wasn't clear was what's going to happen with this, or what's the purpose of this. So I know if I were a landlord, I'd want to know.
I believe that is now moving out of the domain of a question, so. Is there any further questions? Okay, moving on to Member Keating.
When I was reviewing this agenda item, it was helpful to me when another committee member reminded me that there are only 4 types of petitions allowed under the CSFRA, and that helped me to understand that anti-harassment was not in that list, so that we couldn't ourselves in-house fine and manage this.
Jen. But moving on then, seeing no other questions, we will move on to public comment. In-person public comments will be called to speak first. For members of the public online, please raise your hand now or press star 9 on your phone to get in queue. Everyone will have their 3 minutes.
Good evening. Anil Babar with the California Apartment Association. As it should come to no surprise, we're opposed to adding duplicative and unnecessary regulations that already exist under state law. State law makes it legal to retaliate against tenants for exercising their rights. There isn't a need to add these regulations. That can be addressed through simply educating both owners and tenants about what they are allowed and not allowed to do. These duplicative rules only add confusion for both tenants and owners, and ultimately these regulations will add cost and administrative burden to property owners. Mountain View should focus instead on education, not duplication. Instead of creating redundant regulations, educate tenants. And the last thing I want to say is, I don't understand the need for these regulations, mostly because there hasn't been any evidence presented that this regulations are needed. There hasn't been any evidence presented that these regulations, that tenants aren't able to file the same complaints under state law. So I see a lack of nexus between the need for these regulations because, frankly, there hasn't been any data to support it. Thank you.
Thank you. Now we move on to members of the public on Zoom. Andrea, do you want to call people?
Thank you. I will go ahead and ask Madonna Franklin to unmute yourself. You can unmute yourself. Madonna, are you there?
Hello?
Yes.
I think it's a mistake. I actually bumped. I'm not really want to speak.
Thank you.
Okay. In that case, seeing no one else online who would like to give comment, we will bring it back to the committee for deliberations and feedback. Member Satsislip.
Sorry. First, because of people who might be listening, I want to make clear that I'm here in my capacity as a rental housing committee with the city of Mountain View and a citizen of Mountain View, and everything I say is from that perspective and not in my role with the city of San Jose. Overall, just to address Mr. Webar's comment, I think it's not clearly written anywhere what exactly harassment or retaliation is, and staff is not in a position, if a tenant comes forth and says, my landlord's harassing me, to make some legal conclusion about whether what the tenant's describing is harassment or retaliation. So I think there is some value to defining it in regulations, so a staff member could say, okay, are they doing any of these things? Because I've talked to many tenants who make just blanket statements like that, and they may perceive things as retaliation, harassment that may not really rise to that, but rather relate to miscommunication. And also for some of these things address things that are already in state law, like the right to access, and under what circumstances. I've talked to more than one landlord in the past 10 years that thinks it's okay to do monthly inspections. So even though those laws are out there, being able to define this is what's okay, this is what's not, would be an education tool. Okay. I have like comments on a few things. Would it be best if I split them? Asking the chair, just get them. Okay. The first one I'll go through it's in the D, anti-harassment provisions, under example of harassment. A, quiet enjoyment, the first little letter I, this is page 5. This is interrupt, reduce, terminate, eliminate, or fail to provide housing services as required in the rental agreement or by law. I believe it needs to say without a corresponding reduction in rent, because a housing service could be removed, but wasn't intended to harass or anything. But maybe there was a washer and there's no longer a washer, so there needs to be a reduction in rent. So just opening the door for there's ways to do that where you're compliant with the law.
Might I address that very quickly? So I think, saying in bad faith is intended to address any situations where a landlord is doing things legally. It's supposed to basically rule out all those scenarios where a landlord is taking legal actions. So yes.
Okay, then that probably I think that's what, and that was the crux of some of my other comments about habitability, is that and I had to go, I kept reading going all the way back to the first paragraph, like trying to make sure I understood this, but I think bad faith needs to be, maybe it just needs to be clearer, because it's a laundry list of things, and it looks like I can see somebody reading this saying, like, I failed to perform necessary repairs, is that retaliation? I'm sure staff will have materials that'll make it more clear, but that was since I missed that, and I'm not a very good reader, apparently. Just about that one. Okay, and then a particular, on the access portion, so C, subpart, or it's VII 7, the providing a notice of entry that fails to provide the approximate time window for the entry and provides a time window that is unreasonably excessive in duration. I think that needs to be qualified, given the reason for the access, because you could be doing a bunch of balcony inspections in a building and you don't know when the inspector is going to get to that unit. So if you're saying this is happening that day, is that unreasonable? It seems too broad when it says unreasonably excessive. I think you need to just pair it with given the reason for the access. Let's see. Oh, under the forced vacation, E, misrepresentation, III, 3, repeatedly mistreating an occupant of the rental unit through in-person conversations, social media postings, or messages, or other communications with language that a reasonable person would consider likely to cause fear or provoke violence. I would add, before likely to cause fear, provoke violence, also offensive language. So I've seen that happen too. So just adding that too, like offensive language and language likely to cause fear, provoke violence. Again, that's the bad faith thing, going back to, because we're so many pages away from where it says bad faith. Which section is this? Forced vacation misrepresentation, the last one, 8, VIII. Remove or eliminate one or more housing services to cause the tenant to vacate rental unit. I feel more comfortable if it said induce or with intent. So it's not but again, I think it's supposed to be captured in bad faith, but I didn't see that. Okay. Okay, now, wait. I think other acts, page 11, IV4, force a tenant to vacate a rental unit in a hotel, motel, inn, or other transient facility before they have occupied the rental unit for 30 consecutive days and re-register. I think it just needs to be like require them to re-register. So it's, and maybe that's just cleaning up, making the language a little more simply of you're told to move out and you have to re-register so you're not triggering the tenancy. Okay, my last, going back to the complaints. I have a lot of concerns about this because I could see it being abused, and that how long would these complaints be held? There's been not all landlords, not all tenants. I can think of a couple tenants that are probably known to this group that might file a complaint every week about harassment, or are mad about it. And I could just see it being abused, and that there doesn't seem to be any limits with the substance of the complaint. How long will it be kept? I think, like I said, all the other parts about I think how long it will be kept, and then making it very clear that, you're not doing anything with them. It doesn't mean anything. If there's enough, there might be referral to city attorney's office, and the ability to provide a response. But if the purpose of this is to try to get some substance to all the things you hear about, I think that's helpful, but this seems like a way that could almost be harmful, used to harm.
Question, what would you like to propose instead?
So I've only been on the rental housing committee since April, so I wasn't here for the other discussions of what the direction was. If there is a way, you log interactions, I imagine, with tenants. If you have this laundry list, you can log your interaction and tick the box of what they're saying is retaliation. And then you get enough of those over time and you start seeing patterns. That's when you can say, hey, let's refer this to the city attorney's office. But making this whole complaint thing, I think, is going to give the wrong impression to tenants that the city's going to do something for me. It's going to be frustrating to landlords who feel like there's another thing that can be filed against them. They may not understand, but I think having a cleaner, a way of tracking those types of interactions and having a specific, I think that would achieve okay, there's a lot happening here, let's refer it to the city attorney. without it being a formal process. And as I said before, would there be proof, would a tenant have to say, yes, here's my lease, I live there? Because if somebody is, there's bad actors out there who might use the process to poke at someone's reputation or harm them in some way. Okay, I'm done. I'll let other people talk.
Is there anything further staff would like to say, or we can continue on discussion then? Okay. Go ahead, Naz.
No, I was just gonna say, I mean, it does have language, and the goal would be to include language on the form itself, making clear that this doesn't mean that the acceptance of this does not mean that it has been determined that this has actually occurred, or that the city is going to actually do anything on behalf of the tenant. That is 4A in that section. So that language is there, and I think it would be included on a form as well. I also think that there are other actions or things that the city could do that are not something so formal as referring to the city attorney's office. Even going back to your own comment, committee member Hislop, about if you're getting a number of these, if the program is receiving a number of these, is this an opportunity to send people to mediation so that they can talk about the communication issues or whatever they're having that is being perceived as harassment or retaliation? Or is it an opportunity to educate a landlord and reach out to them specifically and say, hey, we're getting complaints from multiple tenants about something that you did that they are perceiving in this way. We just want to share this information with you. So I think it doesn't have to be so extreme as, the city is gonna suddenly sue this person. It can be a softer touch. But yeah, I just want to share that there were additional reasons for getting that kind of information.
Okay, go ahead, Vice Chair Cox.
Yeah, I'm thinking a lot about committee member Stats Hislop's comments. I mean, the one that I'll echo is that I also want to thank committee member Balch, for asking questions about this whole idea of the complaint, because, it wasn't even, I did throw in a question about this to the staff, and I also want to thank you. I threw about 8 or 9 questions there, and you answered all of them. So thanks for taking the time to do that. But I mean, so it gave me a lot more clarity of what's going on here. I do agree that with regards to the complaints, a little bit more explanation would be in order when you draft this up, and in particular, I think there was a good effort to make it clear what the purpose of the complaint was and what status it has. It doesn't have the status of bringing something to court. That has to come later, okay? But I do agree that it should be in there something about how the landlord can respond, once he's gotten this complaint. And I think that there's value there in having whatever he responds to on the record. I'm wondering, when it comes to filing the complaint, whether a person who's doing this is expected to come to the housing staff, and to ask, talk it through with them before they do that, or they can just file it and, like somebody brought up with example, they can file it every other day, without even any intervention from, RHC staff. What do you say?
Well, I think when a complaint is filed, of course, we're going to follow up with the tenant and discuss what is actually happening, and then educate the tenant from whatever it is that he feels is an issue, whether that needs to be categorized as harassment, retaliation, or totally something else.
Okay. That reassures me, about, the process, that I think it can be an effective one. The most important thing I think this brings through is I really like the example that the idea that we have examples of specific things that can happen, so that, we can, the idea of taking something to court is just, so mind-blowing for so many people, right? That, they wouldn't even envision taking a step toward it, knowing how much they know and how tough it is to get through, court action. And so I think the value of this is that if we codify something, in these regulations, it makes it more accessible to a person to reason through whether or not he has a case to go to court. And it also opens it up for either staff or mediation or somebody that they can talk to ahead of time before they have to take that big plunge. And that's really what I see happening here as a very good thing, and that's why I want to, in general, support this. Beyond that, I'm going to call out, some specific ones. In particular, I was really happy to see the statement that if a rental unit's vacancy caused by a violation of the CSFRA or MHRSO or its regulations can only be re-rented at the lawful rent in effect at the time of the vacancy, because that makes it very clear that that no one can try to use sleight of hand in order to get a rent increase by getting a new tenant. So having that said explicitly is of great value. And the other thing I think that is also of great value is the statement you said, protections provided by CSFRA, MHRSO, or its regulations cannot be waived by the tenant in any written or oral agreement or in any other type of agreement, such as settlement agreement. And why I think that's key is because, so many times these days, even online, right? They put up several pages of stuff and it says, have you read all this, and check, okay? And, in reality, we all legally should have read all of that stuff. But, this ensures that somebody can't put something in a lease that somebody might check off and waive, and I wish everybody, when it came time to a lease, because a lease is like really important, that they would actually, read all of it and even understand all of it, okay, before they sign the lease. But I think the common practice is that people looking at, I want to rent this apartment and here's the lease, and if I don't sign it, I don't get the apartment, okay? And so, they just figure like maybe there's no point in reading it. So this kind of language is very, very important too, and so I want to thank you for that as well. But yeah, in general, I'm just saying that, I think the key thing is to make it clear to people by common examples that cover the vast majority of cases of what this could be, really helps people understand, and it also helps them get back to, getting contact with the people that they need before they go to court, okay, to understand, do they really have a case, and is there something else they can do before going to court? So, yeah, those are my comments.
Member Bulch.
So understanding that what we're talking about is creating regulation that is not under the Rental Housing Committee quasi-judicial status, but we're talking about a traditional court process of adjudication. I don't understand then it sounds like then the practical effect of this proposed regulation would be to provide guidance to look down the list and see, does the city of Mountain View believe that you have a case? You're not yet.
I also think it's an educational document.
Yes.
It is a document that we can use to guide tenants and landlords when they have questions. And so the main purpose of this is to prevent harassment and retaliation from happening. So that's what we hope is the major effect of these regulations.
Okay. Then what I'm struggling with then is that I'm looking at the California Civil Code, or several sections of it, on current anti-harassment rules. And I see that there is a difference. The proposal for the city of Mountain View enumerates many examples, whereas the California Civil Code has more general high-level statements. But that's what a court of law is for. In a court, you bring your claim, and through the legal process, that claim is either validated or invalidated. So I'm trying to, it feels to me like this is a very heavy-handed process merely for education. This is actually not about waiving rights, because I did check, and it is already illegal. It is simply invalid to have a lease that waives these rights. That would not be enforceable if the landlord said, well, tenant, you signed this 100-page lease that you didn't care about because you were trying to get an apartment, you're so desperate for housing, I got you. No, that would be invalidated. So I would think that if reasonable people could agree that there's a whole bunch of things which are not good. Like, for example, I'm just going to pick out one. I read you can't effectively sexually assault or harass a tenant. I mean, goodness, I think we would all agree that that is not appropriate, right? I mean, so we don't need legislation or statute to make a list of really bad things that people shouldn't do. And then no, hold on. And then the staff, when someone comes in and says, I have a problem with my landlord, I mean, look at the things they did to me. So you're like, yeah, I mean, we can look at the California statute and look at this, look at these terms and say, yeah, you probably have a strong case, but we're not attorneys. We're not going to represent you in court, but there are these legal resources in the community that could help you. That seems doable today, that there's nothing preventing that. And so I'm struggling to understand, since we're not defining something that's going to be acted on by a hearing officer or the rental housing committee, we're talking about a court of law. A court of law already has a process to, I hope, validate that sexual assault is a very serious form of harassment. So what is the actual effect here?
If I might. So I'll start with retaliation and harassment cases are extremely difficult for tenants to prevail on, specifically because oftentimes the courts say there's no specific guidance that what this item is retaliation or harassment. So there's not really anything for tenants to hang their hat on and say, look, it is, because the state retaliation laws are written so broadly and so not specifically that oftentimes it is difficult for tenants to prove that. So this does provide guidance that a tenant can share with a court in making its decision. Another thing that this does as well that state law does not do is that the regulations provide for a certain number or a certain amount of damages for tenants. And that is oftentimes, a way to prevent harassment from happening if someone is looking at, oh, wow, I could be in a lot of trouble monetarily if I do one of these things, versus it's not so clear in state law what those necessarily are. And then, I think we talked about this at the study session, but state law actually does not define harassment. It defines only retaliation. So it only talks about a scenario where a tenant has exercised their right and then their landlord retaliates against them. It doesn't talk about a scenario where the landlord's motive, for instance, is merely, I want to charge a higher rent for this unit, and so I'm going to make my tenant's life really difficult in order to get them out of this unit. So that is, another thing that state law really doesn't address, that this is intended to explain and define. So I would say that those are additional functions besides just like education, that adopting local harassment and retaliation rules is intended to do. And then the last thing is, state law talks about exercising your rights under state law. It does not talk about exercising your rights under the CSFRA and then your landlord taking some adverse action against you. So, it does also add that and clarify that for the purposes of the CSFRA. If I do X, Y, and Z under the CSFRA, and then my landlord takes a certain adverse action against me, that constitutes retaliation under the CSFRA or the MHRSO.
Yeah, can I also add that this does clarify that it is also an affirmative defense to an eviction, which is really important when you're in the eviction court to have that specified.
Yeah, and I'm trying to parse this in real time, and so I may not be doing the best job. But I mean, like for example, I'm just reading this in 1942.5, whatever I'm looking at here. Causing the lessee to quit involuntarily, right? So if the lessor retaliates, because, et cetera, so quitting involuntarily, right? So basically forcing the tenant out by adverse actions, right? And I'm just trying to process how that would not be the basis for a court to find in favor of the tenant plaintiff if the landlord is trying to is forcing them out to raise the rent, and they're doing taking some action. Yeah, go ahead.
That section you're talking about starts off though by saying if the lessor retaliates against the lessee because of the exercise of their rights by causing the lessee to quit involuntarily, right? So it's only after the tenant has exercised some sort of right, not just because they're merely existing in their unit and their landlord wants to get them out or doesn't like them or whatever it is. It's only after they have actually exercised a right under state law, such as one of the example that's in there, of complaining about tenant inability to an appropriate agency. So they've complained to some state agency about, or even local agency about habitability issues, and then their landlord causes them to quit involuntarily. But what if they haven't done that? They haven't exercised any sort of right. They're just living in their unit and their landlord is like, I can't make money based on the fact that your unit is rent controlled. So I just want to get you out. So I'm going to do everything in my power to cause you to quit involuntarily. And even the phrase cause the lessee to quit involuntarily, what are the sorts of behaviors, harassing behaviors in which a landlord engages in order to cause a lessee to quit involuntarily, right? Because a landlord, in some scenarios, landlords, and this goes back to education, but also to clarifying for a court or providing guidance to a court, a landlord might think that the behavior that they're engaging in is perfectly appropriate, because they simply don't know the laws, or they don't know, what is okay. And so defining that and having a place where if they come to staff, where the tenant comes to staff can say, no, what you're doing is actually the type of behavior, the type of harassing behavior that we have seen that will result in your tenant leaving their unit, involuntarily.
Yeah, if I could just follow up on a couple things there, because I think you raised a couple of good points with this specific example. So One is which we've talked about a moment ago, the guidance of what is probably harassment or retaliation. And that's where we get into the education component, which may be achieved through other means, because I would imagine if I had a concern and I went to an attorney to say, hey, I think I'm not being treated well, do you think I have a case? The attorney would be able to look through the history of case law references and say, well, are they doing X, Y, or Z to you? If they are, then I think you have a case. So our staff could do something similar to that, but even though not being attorneys, I would imagine. The second point is around, so yeah, in this civil code here, complaint to an appropriate agency. So in the case, let's say, for example, that the Rental Housing Committee did approve some type of regulation as being proposed, would our staff in effect be a substitute or a local appropriate agency? I think the answer is yes. You're the agency, right? In that case?
Well, this specifically talks only about tenantability of the unit, which is habitability issues. So it's going to be the RHC. It's going to be, this would cover the petition process, because you're making a complaint to the RHC. You're filing a petition.
Yeah, and maybe my vocabulary wasn't right. What I was saying is that in this particular statute, 1942.5, there is let's say the trigger is making a complaint to the government, some government representative. I'm making a complaint to the government. So if we were to approve something like what we're talking about here, our staff here is the government. Is that true, or is that not a good comparison?
Yes, but that section is specifically limited to complaints about tenantability.
Okay, nothing
about harassment. Anything else, it's habitability issues.
Okay, so habitability versus harassment.
Right.
Okay, thank you.
And wouldn't we also say for retaliation, Nas, that if you feel like you're getting retaliated because you file a petition, that is more like a local law and not under state law?
Right. Yes. Yeah. Like I said before, there are some specifics about the rights that a tenant has under the CSFRA that are not necessarily covered by 1942.5, because it talks about exercising their rights under state law. It says this chapter, which refers to the civil code chapter that we're in, and not the CSFRA. And so, defining that. But Committee Member Bulch, you make a good point that some of this is things like sexual harassment, I think we are clear on. I think there are certain other behaviors that are less clear, like, for instance, sending your tenant tons of text messages after they've told you, I don't want you to communicate with me by text message at 10 p.m. That is harassing behavior, and that's not clearly, I think a lot of people might not, because of cultural norms and things like that, might not necessarily think that is harassing behavior. And so it's defining those sorts of things that will help landlords and tenants understand their relationship, their responsibilities, and their rights.
Will that be all, Member Bulch? Okay. Member Brown?
Thank you, Chair. This is the kind of thing that I really appreciate that we can do, is serve as a resource to landlords and tenants to be able to collate all the information from state law, match it to the local things, and be able to have a concrete resource. Just because someone can look up each word in a dictionary doesn't mean it's not nice to have a glossary of terms that are helpful in a given scenario or a case. So, all respect to Member Stats-Hislop, I would like to disagree with most of the line item changes for the wording. because I do think the bad faith, it does encompass a lot of the things in there, and that. Oh,
I backed off the bad faith.
Oh yeah, no, well, like, things like excessive. I feel like excessive implies that there is a reasonable thing. So saying excessive in context is redundant because excessive implies a context that would mean there is a not excessive form of it. But also the offensive language. I think that the reference in the text to language that's intended to cause like fear or harm, fear or provoke like harmful behavior is the defensible way to police any speech, and that otherwise just declaring something offensive is difficult to defend, because a lot of things I say are offensive to someone. Oh, please.
I mean, offensive language. That doesn't, like using swear words repetitively. That some people get very offended, and it feels like harassment, and it's just somebody using a lot of expletives. So
we have no problem in tweaking the language here and there. I wrote everything down that was said and discussed here tonight. So we have no problem tweaking the language in certain ways that was brought up in front of us.
Oh yeah, no, I know. I was objecting to tweaking the language. Yeah, because I liked the cleanliness of the existing language. I do think this is something that has come up to me from tenants and people in the city before who are concerned with harassment and who have assumed that they're being harassed and want to know what we can do about it. And having a resource to be able to point them to say, if it is one of these things, definitely you should reach out. If it's not one of these things, still reach out, because that's why we have like city staff that are dedicated to helping tenants. But being able to have this as a shorthand is something that we can point landlords or tenants to, I feel like is going to be fantastic. And also something that would save a court a lot of time in trying to figure out, was someone informed or did they have the information available to them to know in advance that the behavior that they were doing could constitute harassment in this context? I think is going to be very helpful. So thank you.
Member Keating.
Thank you. Thanks to my fellow committee members, I have multiple comments. I guess I'll start with a question. So harassment, how is that not loss of quiet enjoyment? And then how is that not a habitability petition?
There may be instances that it could be, but generally it is not considered something that is subject to a petition based on the case law.
Thank you. My next comment was, inspired by Committee Member Balch saying, of course, sexual harassment or sexual assault is, inappropriate and wrong and all these things. But it can be subtle, and I think it's wonderful to have a way to record, and that it has to go to the landlord to say, when you do this, it doesn't work for me. I feel harassed. I feel whatever. And, to give a sample sentence, looking good, honey. I mean, that is not always harassment, but day after day in certain contexts, that could be harassment. And I think it would be appropriate, and it could be to the extent of someone wanting to leave their rent-controlled unit, and that would be a shame. And I think that allowing documentation of what is reducing the enjoyment of their unit for the tenant is a wonderful thing that we can give. Related to that, if this language is already in the document, thank you. And if it's not, I'd just like to suggest it. That one of the things that could be considered harassment would be unwelcome or hostile comments. And, to cover my previous example, and maybe also, the text messages at night would be pretty unwelcome. Maybe it should say unwelcome communications. So One thing I'm wondering about is, I know I read somewhere in this about the idea of tenant bad faith. Is that in the document, or was that just in the staff report? Is that in the draft regulations?
It is in the draft regulations. It is namely provides that if a landlord wins after a tenant has filed a lawsuit against them and shows that the tenant, brought the lawsuit in bad faith, then they can recover their attorney's fees from the tenant, because the tenant has brought this in bad faith and they lost because of that reason their case against their landlord.
Thank you. And thanks to Committee Member Hislop. I'm thinking of specific instances of tenants who might, engage in such behavior. And, I think a preponderance of submitting this form to document I'm being harassed would be helpful in a sense to the landlord to say, isn't this ridiculous? And to have, in a sense, the tenant would be indicting themselves as a inappropriate, behaving tenant. So I'm also thinking of one of the appeals we had that involved cameras and tenant-to-tenant difficulties that the landlord didn't mediate. And so I'm wondering if somewhere in this, and maybe it's not even in the document, but is just to remind the landlord of their responsibility to intervene when a tenant is harassing another tenant. So I'm not sure where that fits, but it seems relevant to this discussion. And, I wonder if we could add language that says, where we identify harassment or we identify retaliation, if we could have, maybe it's in there already, language that says includes but is not limited to. Because there will be something that we don't think of that will definitely fit.
Yes, it does. Both the retaliation and harassment sections talk about this being a non-exhaustive list, and so they're,
Thank you. I think I'm almost done, but I have one more comment. I too am not terribly concerned by the possible overuse of this process, and I think there's value in the formality of submitting a form and that form going to the landlord. And I think that might get some good results from the landlord who doesn't like things so well documented and thinks they're flying under the radar with being a little sketchy. And then I also just wanted to point out that tonight we're talking about, and when it comes back to us, we will pass, presumably, this ordinance, this ordinance or regulation, thank you, adopt it, okay. But then that's not the end of the story. Then there's an FAQ that goes on the website that summarizes it, that's much more friendly and that we can tweak. And so I think we're heading towards a good result when I think about the whole process. Thank you.
My turn. I will begin with a very hypothetical question, maybe a little premature, but regarding the vacancy control section in case of a situation where a person was unlawfully vacated their unit and another person comes in. Can the person come in, if they had a different rent set, can they file a petition on that as being unlawful rent? And is that a way that the RHC actually can?
Yeah, that's an unlawful rent. It's under state law as well.
Yeah, but wouldn't that require the hearing officer to make a determination about that if they did not go to court? Or is that just, it can only be done?
Yeah, they may have to bring in the court proceedings.
Okay, sounds fine, just checking. So yeah, I'll give my broad stances. I believe it is true that we're not really creating a new cause of action, right? We are, in a sense, restating the protections under state law, as well as restating the protections under the CSFRA. We're just compiling it into a single location. What? An MHR, so let's not forget the other one. We're here to kind of collate them for the purposes of educating both tenant and landlord what we expect of them to do. But given courts and us in general, we don't like vagueness. We want things to be more concrete, more defensible, and more actionable. I will note that the complaint procedure, our staff does not make any determinations on it. We pretty much just passively accept it, correct? Yeah, so that means we don't really act. Maybe we can refer them to mediation, maybe we can refer them for other reasons, but at the end of the day, we just accept it. It's pretty much used as a notice requirement because like everything else we do with the CSFRA, we provide notice, even though technically speaking, if you're following the other state laws without CSFRA, you could choose to sue immediately. You know, some tenants have done that. But by opting into this complaint process, we do give the ability for a landlord to react for a period of time, you know, make adjustments before, if it ever comes up into a court of law. Because again, the CSFRA is meant to try to harmonize that kind of relationship between the two sides rather than, you know, push things further. I do like the fact that as kind of the carrot side of things, we do provide a set of minimum damages, or as well as maximum in the sense, to at least give an incentive for people to opt into the process. And that is, I believe, all my comments at the point. Member Walsh?
Yeah, thank you. So I have one comment and then a question. So the comment is, I'm continuing to hear dissonant language. Multiple committee members are talking about documents in education, but we're actually talking about a regulation. And I don't consider a regulation to be merely a document or education. I consider it to be an attempt at law at setting and in fact it is basically talking about setting up the basis for the court to operate. So I really don't think we should be using casual terms like document or education when this is regulation, because they have much different weight. Documents in education do not require regulation. That can be done in many ways. Okay, that's my comment. My question is this, so I understand the distinction of harassment and retaliation, or I think I understand it anyway. I'm sure there's a technical thing. So the thing which is really hard for me to understand, when I search for California anti-harassment for tenants, first of all, voluminous results come up. Public sector and private sector. And let me tell you what I mean, because I am not naive. I know that there's hyperbole. I know that there's marketing. I know that there is manipulation in advertising. So law firms, you know, there are lots of examples of law firms who basically give all sorts of information, referencing all the codes that we've talked about, 1940.2 and the others. They're all here. And they all have the same basic information. You know, yes, harassment is illegal. And basically hire us and we're gonna help you fight that guy, right? So every law firm is saying that harassment is illegal in California. We will fight your case. But I'm not naive. I realize that they're trying to make a buck like we all are, and they're basically using this as a way to collect people that they can, you know, use for their business as is their right. I don't mean anything negative about that. Okay, but now let's go to government. Government is not making money off of people having lawsuits, I don't believe. So the Association of Bay Area Governments, California State Civil Rights Department, they state explicitly anti-harassment. In multiple locations, it is very easy to find. So I'm trying to understand what legal nuance am I missing? I understand the concept that the current state statute has language which is general, and the proposal is to be more specific. I totally understand that. But again, courts routinely, my understanding is, part of their job is to find, does a particular example fall under a statute? That's a regular part of the process. So how is, I'm not understanding forget the law firms, because they're just trying to make business, I get it. But the state agencies are being loud and clear that tenant harassment is illegal. What is the disconnect there? Or do we not know? Maybe this is an answer.
No, we
Okay.
I mean, I think Naz is going to answer. Don't worry.
Okay. Thank you. Okay. Sorry if I was.
No, I mean, I was actually going to ask a question of like, what do what are you pulling up that says that harassment is?
Sure. I mean, so just a couple. I've seen so many searches. A couple of examples. So, Civil Rights Department, State of California, housing. So, Cal Civil Rights, CA Gov housing. California law protects individuals from illegal discrimination and harassment by housing dwellers based on certain protected characteristics, whether or not someone is actually perceived. The law also protects against discrimination and harassment based on more than one or intersecting characteristics. All sorts of things there. That's an example. Then there's
just limited to discrimination.
In that particular
That's the only instance that the CRD
but it
can
says
govern.
harassment, though. In that.
Harassment based on discrimination.
Yes.
That the
Based on
Civil
your
Rights Division
protected
has limited
status.
jurisdiction, and it is based on discrimination based on being a member of a protected class.
Okay, understood. So then there's the Association of Bay Area Governments has a PDF on their website from September 2025, so within a month, September 24th, 2025, so 30 days ago. And it says, yeah, that's it. So 1940.2 prohibits a landlord from using force, willful threats, menacing conduct to influence a tenant to vacate a dwelling. The law also prohibits a landlord from threatening to disclose information regarding the immigration or citizenship status of a tenant unless otherwise required by federal law. There's a similar paragraph below for 1942.5. There's, so that's an example. I'm just trying to understand what.
The Association of Bay Area Governments site is actually recommending that local governments adopt a tenant anti-harassment protections because the state laws don't go far enough. It is part of their sort of package of good government practices that they recommend.
Right.
I think they may even have a model ordinance, although Naz would know better if they do.
Yes, I drafted it.
Yes. So, but that's...
And it is quite literally it's very similar to the regulations that you all have, except that yours is tailored to the fact that you have the CSFRA and the MHRSO.
Right. So this is part of... So California law requires affirmatively furthering fair housing. It's part of the housing elements and part of cities getting their housing elements approved. A lot of cities have included programs to include tenant protections to deter displacement and affirmatively further fair housing. So ABAG has put together a packet of sample provisions that local government can adopt, and that includes a local anti-harassment ordinance.
So the pivotal point then is that they're saying that the civil code already prevents it, but they're saying it's not specific enough, and so they recommend cities get more specific because even though it's already against the law, for whatever legal reason, it's not adequately enforced.
Right. I mean, what they're saying, reading from their website, is local anti-harassment ordinances can reduce displacement pressures and informal evictions by clarifying what constitutes harassment and retaliation and empowering tenants to stop it.
Yeah, and that document that you're specifically looking at under how can jurisdictions implement programs that go beyond state law, it says state law lacks specific language defining harassing behavior, which can make violations difficult to prove in court. So, the sentence before what Karen said. Yeah. So that is, as we mentioned, one of the policy decisions to adopt something that is more specific that helps in court, but also even hopes to prevent these things by making it clear to both landlords and tenants what their rights and responsibilities are.
I will grant Emily a direct response.
I just wanted to provide an example to Committee Member Balch. There's anti-discrimination laws or harassment laws with respect to employment and, generally speaking. I still have to sign at the City of San Jose, like the policy. We have a policy manual that lists out all the examples and what everything, what can constitute harassment, and it goes even further. And we have to sign that, and we have to do trainings every 2 years. But it's it's like our regulations for being employees of the city. So there's some analogy there. Like, even though there's laws on the books, they still gotta flesh it out a little more so people understand.
All right, moving on to Member Brown.
Thank you, Chair. This is a good find. I think there's something we should probably link to in our webpage if we do adopt this. I forgot in my earlier comments that I also wanted to voice support for the complaint process to have a formal thing. Because right now, any tenant could email the housing department with their complaints in any way, and that does become a public record because they're communicating with the city. And so there already is a process that is undefined of just emailing your complaints to the city and landlords. But having some guidance there and a formal thing that helps us to parse it and add structure, I think is going to be nice. I know, but yeah, exactly. So they can already do that. So having a form for it would be simpler. You now have a defined structure, so it's not just a 3-paragraph long or 16-paragraph long email about how you've been aggrieved in all these ways that you send every day because no one's listening to you.
So thank you all for your feedback. We heard all the proposed maybe language tweaks. The only thing I want to have feedback on is, do we want the complaint process or not? I need to, maybe a straw vote or something.
Well, first we'll go with Edie, who's last in the queue, and then we can go into the discussion of the straw poll.
So if I'm living in a fully exempt unit, do I not get to file a complaint?
Correct.
Thank you.
We will still talk to the tenant, but we have to then refer them to the general resources, not specific to the CSFRA or the MHRSO.
Yeah, that's a reminder that, the regulations we're doing tonight are only done under the power of the CSFR and MHR. So there are powers that council can take, but we're not council. Okay, so direction of staff, we are going to make some direction. Actually, before that, can staff currently summarize what has been staff's summary of what direction has been so far?
I like to confirm, from what I heard, is the majority at least wants to move forward with the regulations, maybe some word tweaking, and I would like to get more clarification if the complaint part needs to stay in there.
All right, we can do that. That's okay. For now, we will limit discussion to any discussion regarding the complaint process, but I am open to a straw motion if anyone wants to make a straw motion. Member Stanislav.
I've listened to my fellow committee members, and I see the advantages and the positives from the complaint process. So I just want there to be some balance and some consideration for unintended consequences, but I think I raised those, that there could be a response, that there's some time limit to how long these are kept on file. So just wanted to share that.
Member Brown.
Okay, so for a straw poll, I'd move that we do include the complaint process in any, so I guess, jump the gun. I would like to move that we do bring back regulations to adopt at a future meeting.
I think we can skip that particular motion again.
Can we?
What? Just focus on the complaint right now.
I think I heard the majority at least in favor of moving forward with adopting regulations, but please take a straw
Sure,
vote
okay.
if you like.
Straw poll and moving ahead with the regulations. Raise hands if aye. Okay, raise hands if nay. Okay, raise hands if abstain. Seeing none. Okay, so that straw poll passes. All right.
Okay, now I'd like to include within that the complaint process as defined in the proposed draft regulations.
All right, any discussion on that straw poll? Vice Chair Cox?
No, I mean, I listened to what committee member Stats Hyslop said, and I do think that additional clarity, okay, in terms of like, when you make the complaint, I mean, you know, that it would say explicitly the landlord would have the opportunity to respond. And I don't understand why she wants these documents to disappear after a certain point, because I mean, I think that there's some value, you know, statistically at least, with respect to a particular landlord, if there's a recurrent behavior going on, or just in the city in general, so that we can, you know, you can use those statistics to motivate whether or not we have a future study session item about a recurring problem. And if you disappear the stuff, I mean, you lose that. So maybe I'm missing the point, but I don't see why disappearing.
Sure. Really, I'm trying to get into the head of how landlords may take this, and I think some people just wouldn't want. What if I had one begrudged tenant and they said all these terrible things about me, and that's going to live in the city files forever? These are just things that when I'm reading through that struck me. That doesn't mean I have to have that. There were just questions I had, and I could, you know, I see your point too. But that was really the reason, was that, you know, thinking about those one-off things. But I can see for a long-time landlord. I got it.
Okay. Should I respond to that, or you want me to wait?
Actually, can I ask a question of council? Under the Public Records Act, are we allowed to dispose of records? And
Yeah, I mean, I assume the city has a records retention policy. The Rent Stabilization Division could have a records retention policy specific to these complaints.
Thank you.
I also wanted to add that we had a similar discussion in the Rental Housing Committee way in the beginning when we started up about frivolous petitions being filed. We have not seen any. So, yeah.
Go ahead, Vice Chair Cox.
Yeah, I'm just wondering, I mean, I understand the scenario you're talking about, but I mean, you know, I'm just wondering if that could be remedied by having staff like review the complaints as to whether they view them as a nuisance. And, you know, I mean, like, you know, and then kind of like when we ask for, we try to decide whether or not something's a persistent problem, you know, I mean, if it looks like it's an, you know, these things have been given up as nuisance complaints, that they be excluded from the data. I mean, you know, it would be a judgment, but I mean, I really just see the value of trying to look at trends over time, okay? And with respect to particular landlords, we have some landlords that own like large percentages of units within this city, okay? And so, I mean, that can be a useful thing.
I mean,
Yeah, can I just say, I don't think that staff can make a judgment call on the complaints without doing an investigation, which is explicitly not part of these regulations. I mean, what I could suggest is that staff can go back and look at a reasonable time duration for records retention for these specific types of materials. If there's a concern that they would, you know, forever haunt a landlord. So.
I was also going to suggest another thing that the committee might consider. You know, if it's just a concern about someone filing this on a weekly basis, is you certainly can set a limitation. You can, you know, as you do with petitions, like you can't file a petition on the same topic within 6 months or whatever it is. And you could certainly do that here and say, like, you know, you can't file a petition on this. I mean, you can't file this complaint if it's on the same topic within 3 months, like 90 days or something like that, unless, yeah, and if you do, then, that just, it will not be retained by staff or in the records or sent to the landlord or anything like that.
Is that it, Vice Chair Cox? All right. Member Keating.
So, being a public document and being able to be requested, I think there are different ways of handling that. Like one of the things, one I would describe as self-serve. Like right now, is my unit covered under the CSFRA? I don't have to call staff. I can look up my unit or anybody's unit, and I get the answer of, is it or is it not covered under the CSFRA? And I could see a quick level of summary information saying, at this property, does this landlord, have any complaints? And just to give a count. And, that wouldn't be, there would still be public records. You could still, do a request and get the detail of the records, but self-serve to just see how many complaints. And if we were going to do that, I think we should also do how many unique individuals complained. Because that might, if there were 40 complaints and there was one individual, that might ease your mind a bit. And as far as limiting, I don't oppose that. Although, if a landlord is behaving poorly repeatedly, I wonder if we shouldn't allow that to be as documented as the tenant would choose to do. Thank you.
Member Balch.
Yeah, I mean, on the point of retention, I mean, it depends what the goal is. I think Vice Chairman Cox, it's a valid desire you've articulated for statistics. Retention is not all or nothing. You could basically expunge the details of the document, but still track whether the landlord has something against them. So I think depending on the stats desired, the retention policy could be adjusted. So what is the goal? And then the retention could be figured out. There is a really interesting point about retention. One of my ongoing disagreements with the CSFRA is the lack of the concept of statute of limitations. I've brought that up in many times when it gets to rent rollbacks. There's just no way to undo that. Let's look at bankruptcy filings. Typically, agencies will only go back 10 years. At some point, there's a reset in society, right? Except like murder, where it's life prison. Basically, my understanding of our government and judicial system is that at some point there's a reset, right? We all get an opportunity to restart. 10 years is a number that sticks in my mind from a bankruptcy standpoint. I'm not sure if that's accurate or not, but something on that order. So if we do, it seems like some kind of retention policy is necessary. It is conceptually mainstream across all aspects of society and government and law, as I can see as a layperson. It's interesting, though, this point about retention, all the commentary is about whether it's good for the tenant or not. I mean, it could be good for the landlord. Having the landlord having a paper trail to go back to defend themselves in court, right, is a real issue. And so it is worth noting that there's a really strong bias in this conversation that it's always the landlord who's the bad guy, and that it's the tenant who's always going to benefit from this. And there are many examples where either party is going to benefit by having a paper trail. So I don't actually view retention as good or bad biasing for landlord or tenant. I think it is an objective data source, and people could look at it and make a determination if it is frivolous or not. Because I certainly agree with what counsel said, that certainly we can't put staff in the position of making a judgment on whether something is valid or not without an investigation, and then that snowballs into a whole process and cost. So that seems inappropriate. So yeah, I think some kind of a retention policy would be important. I really urge everyone to please not look at everything from the perspective of the evil landlord and the saintly tenant. Sooner or later, everyone gets sued, or sooner or later, everyone gets an insurance claim. I remember once talking to a doctor, and she was talking about why she has malpractice insurance, and she said, "Trust me, every single doctor has been sued for malpractice." So yeah, let's not go into the good versus evil. Thank you.
Before we move on to the next speakers, let's remind that the current straw poll, which is still on the floor technically, is just about whether we want to do a complaint procedure as documented as right now. So try to keep your comments to either swaying for or against that proposal. Member Keating?
I'm not sure I will comply, but I'll be brief. I just wonder if, as we consider having a form for a complaint form, should we have a response form available to landlords?
Vice Chair Cox?
Yes, so on the direct question, I mean, do I like what has been written up in the staff report so far about what constitutes the complaint process? I think more needs to be added onto it. And so I'll be brief too in terms of additional comments. I want to also thank Committee Member Balch for raising some important points in terms of retention policy. What I want to say back to that is that, the examples he gives are good ones, and I'll add another one, like one's driving record in terms of how it affects your insurance. If you've got a good driving record for 7 years, that's as good as forever, okay? At least in the insurance companies I've talked to. And the point of it is that, but the issue is the retention policy for these things like bankruptcy and other kinds of things. It's a matter of years, not months. Okay, and so that's why I think, that's the kind of time frame we should be thinking of.
All right, Member Stats-Hislop.
Quick question: would the complaint process would staff find that helpful?
Sorry, could you repeat the question?
Would having this complaint structure process, I don't want to say process because nothing really happens with it, would that be helpful to staff?
I think it would give us an idea of what is playing in the community and give us a better insight on what types of behaviors are out there, whether you believe it or not. It's just an interesting, almost like a survey maybe, for us to understand what is playing out in the survey, in the community. And also right now, people have no outlet to kind of put that out on a survey. I mean, the only option they right now have to file a lawsuit, which I think Mr. Cox said that is really, really, really the last resort for a tenant at this point. So we felt it was a good tool to kind of evaluate what is happening in our community.
Member Brown.
Thank you, Chair. I would like to call the question.
All right, raise hands if you would like to move ahead with the staff proposal for the complaint process. Raise hands for aye. Raise hands for no. Raise hands for abstain. Okay, so that's a majority of the committee. Is there any?
Thank you. Yeah, that's good.
Is there any further direction staff would like?
Thank you. That was
okay.
good.
Is there any other direction that any members of the committee would like? Assume Vice Chair Cox, you have something? Yes. Go ahead.
I'm trying to understand what just happened. So does it mean that we've ended discussion about how to amend or improve the complaint process, or?
Go ahead.
Okay.
This will
it's
come
just
back
that.
to you for approval.
Okay.
Yeah.
Okay.
So you will have another opportunity if you want to refine
All right. Fair enough.
In that case, can staff please summarize what they think our direction is?
In the big lines, move forward with providing regulations for rental housing committee adoption, tweak a couple of passages with added language, and let's see how we can improve the complaint process.
Can you clarify what you mean by the direction on improve the process?
We'll just take a look and take in all the comments that we've heard
Okay.
tonight.
Sounds fine. Any other direction any member of the committee would like to give staff? Seeing none, I will close this item. Okay. Go ahead, Member Keating.
I'm truly interested in having a self-serve aspect to querying this information that's collected.
I think we will need to do a little bit of research on whether that's appropriate, because there might be some due process
and public records, privacy issues that we need to consider.
Yes.
But if it was only number of complaints at a property, would that be still possibly problemsome?
Maybe not, but I think we want to think about that. We'll take that suggestion and come back.
All right, a reminder that this is not the only time we're going to be talking about this topic, so every regulation we discuss can be discussed in the future, whether enacted or not. All right, moving on to item 7, committee staff announcements and updates. I'll hand that back for staff.
Thank you. Is that the tech team up top? Can we make the PowerPoint larger? That's okay. I'll read it. I'll read it. Okay. Thank you. So we'll next talk about. There we go. Thank you. All right. So we'll talk about upcoming office hours and workshops. And before I get into that, I would like to mention, as Committee Member Hislop reminded me, that we did have the wonderful 50th anniversary of the Mountain View Mediation Program last Thursday. We had a really nice ceremony celebration at City Hall, and there was a proclamation that the week of October 13th will be mediation week for the City of Mountain View, so it's very exciting. All right, now back to regular business. We continue to do our virtual office hours every Tuesday from 10 a.m. to noon. Those are online only at the link here on the screen. We did have a workshop today at the Senior Center. It was Rent Stabilization 101, and we held that after their lunch hour, and that was nice. And coming up in November, we have a couple workshops as well. On the 18th at 2 p.m., we have a landlord virtual workshop about how to comply with tenant eviction protections in Mountain View. And then in December, we are focusing on the utility adjustment petitions, as December will be the next upcoming deadline. So on the 9th, we have a tenant focus workshop at 6:30, which will be virtual. And on December 11th at 2 p.m., we have a landlord-focused virtual workshop.
Any questions or comments from committee members? None? Okay.
Perfect. All right, and then we continue to have...
Happy birthday.
Yeah, thank you.
Happy birthday.
Happy birthday. Bless you.
All right, so we do still have our Landlord Help Center every Thursday from 2 to 3 p.m. at our office and online, where any landlord can come and get assistance with any rent stabilization issues they have. And we still have our Tenant Housing Help Center the first and third Thursdays of the month from 6 to 8 p.m. And we have our partners here as well as city staff. So we have CSA, Project Sentinel, and CLESPA available for the community. And that concludes 7.1.
My turn. All right, moving on to 7.2, expected future agenda items for RT meetings. Our next agenda item is an appeal hearing on November 20th, 2025. Are there any additional comments or announcements from committee members or staff? I do have a question for staff, slash a referral, which is that I know that Trejo is up at City Council next meeting, so I would like some notice of what happened at that meeting. Trejo. It would be nice to know what happened. Seeing no other comments or announcements, I will adjourn this meeting at 8:49 p.m. The next Rental Housing Committee meeting is scheduled to be held on Thursday, November 20th at 6 p.m. Night.